Hello and welcome to Topic 10, Lecture 1. And in this lecture, we're going to be learning about pretrial procedures. So in this topic, you're going to be learning about what happens in the criminal courtroom. And as you know from, learning about things this semester, there are many things that happen in the criminal courtroom. And so we're going to divide the activities of the criminal courtroom into two stages. Stage one is the pre-trial procedures, and stage two is the trial procedures. And so in this lecture, we're going to examine the first stage, what takes place in a criminal courtroom prior to the trial itself. And so in this lecture, we're going to be learning about grand jury and preliminary hearing and plea agreements and other activities that take place in the courtroom prior to a trial. In the next lecture, we're going to focus on the trial itself and those procedures. So that's what we've got on the docket. So let's get started. So when we think about the criminal justice system and we think about criminal justice procedures, when we often think about the trial, our mind goes to the trial. And, the trial itself is the thing that oftentimes receives the most media attention, right? And so I think that when we think about that, what is the activity that takes up a lot of the time in the criminal justice system, we think trial. But as you know from this class, very few cases actually go to trial. Only about 10% of cases actually go to trial. Most cases are taken care of prior to the trial. And so as you're going to see, and I've mentioned this before, when you go to, actually sit in on a court activities for your courtroom report that you're going to be doing at the end of the semester, you might sit in on an actual trial, but chances are you're going to spend a lot more time looking at the activities that take up most of the time in the criminal courtroom, and that's pretrial activities. And so the vast majority of court activity is dedicated to pretrial procedures, and that's what we're going to be focusing on in this lecture. And since so few cases go to trial, it's really important to understand pretrial procedures, okay? And so let's take a look at what happens in the criminal courtroom prior to the trial. All right, so let's do a quick overview of the pretrial procedures. And so, this semester we've learned about the 4 stages of the criminal justice process. And this first stage is the policing stage. The second stage is the prosecutorial stage. And the pretrial procedures is sort of like this moment, this bridge between the police stage moving on into the prosecutorial stage. Because as we know, one of the last steps in the police stage is to arrest somebody and to take them into custody. However, as it says there, that an arrest itself doesn't begin the formal criminal proceedings, but a criminal complaint does. So somebody can be arrested and a criminal complaint cannot be filed with the court. And so, you would just basically be let go at that point. But once a criminal complaint is filed, at that point, the criminal procedures begin. And so what a criminal complaint is, as it says there, it's a sworn written statement to the court or to a judge by the prosecutor alleging that an individual has committed an offense and requesting an indictment and prosecution. Okay, so it's sort of it is the legal document that is submitted prior to determining the actual charges that this person is going to be faced with. And so in a criminal complaint, it usually includes who the defendant is, the date of the alleged offense, as well as the alleged offenses as well, okay? And then some sort of brief description of the alleged offenses, okay? So the pretrial procedures really do start with that issuance of a criminal complaint to the court. At that point, then once the criminal complaint is filed, then the determination of whether or not this person is going to be charged with the crime begins. And that begins via either a grand jury or preliminary hearing, or the indictment process or the information process. Okay, so the grand jury is the indictment process for charging. The preliminary hearing is the information process for charging. And we're going to take a look at both of those in a lot more detail in a moment. Next, there's an arraignment, which we've already learned about, but we'll go over that in this lecture as well. At that point, the arraignment is where you're informed of the charges and you enter a plea and bail will be set. And then at that point, you begin preparing for trial, particularly if you entered a plea of not guilty, and then plea bargaining. Okay. So in this lecture, we're going to spend most of our time taking a look at the grand jury and preliminary hearing, these processes for charging somebody with the crime, and we're also going to be taking a look at plea bargaining. However, as you're responsible for learning about all of these in the textbook, and make sure that you read about bail and the issues of bail within your textbook, that a lot of people, as we know, cannot make bail, and that they end up, if they plead not guilty and they can't make bail, then they are bound over for trial and they are sitting in jail, basically, awaiting either trial or awaiting then finally a plea bargain. And so on the next slide, let's take a look at just how many people are in jail waiting for trial. Okay, so this is a slide from the Prison Policy Initiative that basically shows how many people are locked up in the United States, which is very timely given the fact that you all are finishing up your paper or have just finished your paper on Locked In. And so let me put on the magic pen here. The reason I'm showing this is to, basically talk a little bit about those who are held in custody while waiting for trial. Those who can't make bail, have pled not guilty, and are bound over for trial and remain in secure detention. And so in the green here, this is the half of the pie where people have been sentenced to incarceration in a state prison. And so as we know, the vast majority of those who are in prison are held in state prisons. A much smaller portion of the pie here is the being convicted of a federal offense and being sentenced to incarceration in a federal facility. But you'll also notice that there's a significant number of people who are locked up who are behind bars in a local jail. So a local jail is run by the county, and that people in local jails, they serve a sentence that's less than 1 year. And so if you are convicted of a misdemeanor or plead guilty to a misdemeanor, you could get a sentence that could be less than 1 year. And so if you look here on this pie piece here, this is the number of people who are behind bars because they're serving out a jail sentence. However, look at this big pie piece. This is for nearly 500,000 people, 470,000 people who are in jail because they can't make bond and they are waiting for trial. And so that's a significant number of the people who are behind bars in the United States. And then also in the federal system too, you have a significant number here. Now, obviously the federal cases are a lot less than state cases, but if you are charged with a crime, plead not guilty, and then you are preparing for trial in a federal offense, you're going to be held in secure detention by the U.S. Marshals. And so still, you have significant amounts of the pie that are people who are behind bars due to, pleading not guilty in their pretrial procedures. Okay, so once a criminal complaint is filed in a court, the next step is that the prosecutor selects a charge. They decide what they want to charge this individual, if they want to charge this individual with a crime, with an offense, and if so, what charge they are going to select. And so that in a democratic society, that we have a check on the power of the prosecutor to charge. And that's where the charging process comes into play, because the goal of the charging process is basically to determine whether or not there is enough evidence or probable cause to charge a person for a crime. And so that there are two types of charging processes that we're going to take a look at. Both serve the general purpose of checking the charging power of the prosecutor, but the processes are quite different in terms of how that check on the power is implemented. And so one is known as the indictment process, and that's where the check on the power of the prosecutor comes through a grand jury. And the other is the information process, and that the check on the power of the prosecutor comes through what's known as the preliminary hearing. So let's describe both the grand jury and then the preliminary hearing, and then we'll talk about the strengths and weaknesses of both of these processes, and then sort of raise the question about if you are going to be charged with the crime, would you rather be charged via the grand jury or the preliminary hearing? Okay, so let's look at the indictment process that involves a grand jury. Now, a grand jury is actually a jury of people. That's why it's called a jury. And there are two different kinds of juries that you'll learn about this semester and that you're probably already familiar with one of those types of juries. The grand jury is called a grand jury. Why? Because it includes more people. Grand means big. And so grand jury is a much larger a number of jurors who are set on this grand jury. A petite jury is smaller. Petite means small, okay? So there are less people who are seated on a petite jury. But the main difference between a grand jury and a petite jury is the function that they play. The grand jury's role is to determine whether or not somebody should be charged with a crime. They are involved in issuing an indictment. A petite jury has a very different role. A petite jury, that's the trial jury, their role is to determine whether somebody is guilty as charged or not guilty. And so, like I said, when you think about the word jury, what you think about is a trial jury, somebody who determines, a group of people who determine whether somebody is guilty or not. But a grand jury is also a jury, but they have a very different role, that they're involved in placing a check on the power of the prosecutor. But both of these juries are drawn. They are seated according to a very similar process. And so a grand jury is between 16 and 23 randomly selected adults that are derived from, driver's license or state ID registers, right? So you get this broad swath of people that are called for either grand jury duty or for trial jury duty. And that another big difference between a petite jury and a grand jury is that a petite jury is called for a specific case, that they'll listen to the case and they will render a verdict and then their job is done. A grand jury can sit for several months, and that every time a prosecutor wants to bring an indictment forward, they'll weigh in on whether there's probable cause to support that indictment. So there are two major roles that a grand jury is involved in, and one that you're very familiar with, that is the issue of they weigh in on the prosecutor's indictment. And so, it's one major role is that determines whether or not the state's accusation, it justifies a trial, okay? So the prosecutor is accusing somebody of a crime. They want to charge them with that crime. And then they're asking the grand jury, is there enough evidence here? Is it based on the evidence? Is it reasonable to think that this person did engage in this crime? Probable cause. And then the grand jury weighs in and says, yes, they think there is probable cause, issue the indictment, or they say, no, we don't think there's enough probable cause. And then the prosecutor cannot move forward. So the indictment is a written accusation of charges. That indictment is submitted to the grand jury. The grand jury looks at the evidence to support the indictment. And if they feel that there is enough evidence, they will say yes, and they will say that this is a true bill of indictment. Or they will say no true bill. And they will say that there is not enough probable cause to sustain this indictment, and therefore the individual cannot be charged. So we know a lot, we've heard a lot about, or somewhat a lot about that role, about indictment process. But grand juries actually do other things as well, and grand juries can act as a sort of a part of a larger investigation that police and prosecutors are doing. In a moment, we're going to learn that grand juries take place secretly, and that's one of the upsides, downsides of a grand jury process. And so sometimes if prosecutors and police think a crime is going on, before they issue an indictment, they'll engage in what's known as a presentment. And the presentment is where they're basically presenting witness testimony to the grand jury to see whether or not there's actually enough evidence here to issue an indictment. And so, that independent investigating body, I mean, the grand jurors don't engage in the investigation, but they listen to the investigation that's being presented to them. That's a really important role that the grand jury plays. However, we hear less about it. It's also, for the criminally accused, can be kind of dangerous because you could have committed a crime, but you don't know that the prosecutor has called a grand jury to, basically investigate who's being involved in this crime. And so there's a lot of secret activity that takes place that can be quite damning for the person who's ultimately indicted. So one thing to keep in mind about the grand jury is that it's really the prosecutor's show, okay? That grand juries meet at the request of the prosecutor to say, hey, take a look at this indictment and weigh in on it. No judge is present in the grand jury. The defendant and the defense attorneys don't have a right to be present. They may not even know that it's going on because it's a closed or secret proceeding. Now, once, the indictment comes out, then you would know that there's a grand jury going on. And at that point, the criminally accused and the defense attorney can begin to react to it with motions. But really, the prosecutor is the ringleader of the grand jury. And so, what's the purpose of the grand jury beyond seeking indictment? Well, it basically allows, as I mentioned on the last slide, the prosecutor to question witnesses as they, are demonstrating evidence of to support probable causes that an individual is engaged in a crime, and that they can do this secretly. And sometimes a defendant can be called before a grand jury. They don't know they're the defendant yet, but that you can be called in as a part of that fact-finding investigation. And all of that questioning all takes place secretly. So in a way, now if you feel like you have committed a crime, you're going to probably plead the fifth before the grand jury. But, as witnesses are, being questioned, that all takes, it's secret. Nobody knows it's taking place. So therefore, it doesn't really harm the reputation of the person who is being possibly considered for charges because nobody knows that it's going on. It also, because it's secret, that witnesses are a lot more forthcoming because it's taking place in secret. And what happens in a grand jury is oftentimes sealed for quite some period of time. And so there's like sort of an anonymity that can go on. Another aspect of it is that it's for a prosecutor, it's sort of a trial run before the trial. They are questioning witnesses. It's a part of the investigation. So it kind of gives the prosecutor, in a way, a head start. Because they're already collecting evidence that they can use in trial as a part of both the presentment and also the indictment process. Okay, so what's the difference between a grand jury and a preliminary hearing? So let's turn our sights now to not the indictment process, but the information process. So the purpose of the preliminary hearing and the grand jury is the same. Determining whether or not there is probable cause to sustain the prosecutor's charges. The big difference is the process itself. So with the grand jury, as we just talked about, that a grand jury takes place secretly. It also takes place without a judge. The only people that are in the room for a grand jury is the prosecutor, the grand jurors themselves, and a court reporter who is sworn to secrecy. It is really a private event. It's not private, it's a secret event. A preliminary hearing it takes place in public before a judge. And so that, in fact, when you go to the court house, you could easily sit in on a preliminary hearing because it's a part of the public court system. Unlike the grand jury, where only the prosecutor is present, in a preliminary hearing, the prosecuting attorney is present, the defendant can be present, and the defense attorney can be present as well. The process is, different. The prosecutor presents the evidence to the judge, and that evidence can be, documentary evidence, but it can also be witness evidence. And then the other side gets a chance to question it. So the defense attorney there is to sort of poke holes in the evidence that the prosecutor is presenting to support these, to support the charges themselves. And then it's, so the prosecutor will present the evidence that they think sustains the probable cause. The defense attorney will try to poke holes in that evidence, raising doubt, saying there's not enough evidence to support probable cause for charges. And then it's the judge who decides whether or not the charges should be dismissed or if probable cause has been met, and that the individual then will be charged, and then a trial will be bound over for trial. And so that is the big difference between the grand jury and the preliminary hearing. And why it's called the information process is because the information is the formal charging document, okay? So the indictment is what charges an individual. That's the formal document. In a preliminary hearing, it's the information that is the formal charging document. So as you're thinking about the grand jury and comparing, contrasting the grand jury or the preliminary hearing, maybe think to yourself, what are the benefits of the grand jury? What are the drawbacks? What are the benefits of the preliminary hearing? What are the drawbacks? And if you were facing charges, which would you prefer? Would you rather have the charges come forth through the indictment process or through the information process, through a grand jury or through a preliminary hearing? And thinking beyond yourself, not just that, which would you prefer, which system do you think is fair? So, there are definitely drawbacks of the grand jury. I mean, one is that the defense isn't there. The accused may not know that they are, being investigated and subject to an indictment because it's a secret proceeding. But on the flip side of that, one of the benefits is that because it's secret, that if they don't issue an indictment, then nobody knows that you are actually under consideration for being charged. Since a preliminary hearing takes place in a public court, if you have a preliminary hearing, people know that the people are considering charging you with a crime. And even if the judge says there's not probable cause here to support those charges, it's still out there in the public. Another benefit of grand jury could be that it's actual jurors who are deciding whether or not there's probable cause. In a preliminary hearing, it's the courtroom work group, and so maybe that's not a true check on the power of the prosecutor. And I'll leave it to you to sort of think about what are some other drawbacks and benefits of each of the processes for determining charges. Okay, so the next step in the pretrial procedure is arraignment. So once a person is charged with a crime, they must be told of those charges. That is basically in the Constitution called the writ of habeas corpus, that when somebody is charged, they have to be informed, that they have to be brought to court and told why they're being charged with the crime so that they can adequately prepare a defense against those charges. So being told of the charges takes place at the arraignment. It's at that point where the individual is brought to the court. The individual being charged with a crime is brought to the court. The judge informs the defendant of the charges. They determine whether or not they understand the charges, because the Sixth Amendment says that a person must be competent to stand trial. And so in an arraignment, not only are you being told of the charges, but you're also asked to enter a plea. And you have to be competent in a sound mind in order to understand the charges, in order to enter a meaningful plea. If you are incompetent, whether that you're completely intoxicated or whether you are mentally ill or have some sort of mental disease, you could enter a plea, but you don't enter the charges. So it would, really make the procedure sort of hollow and anti-democratic, small d. And so the judge will make sure that, do a quick sort of evaluation of the competency of the defendant. And if they are found to be not competent, then they will make sure that that person becomes competent before they can actually be charged and tried. If they can never be found competent, then they can't move forward at that point. After you say that you understand the charges, then you are asked to enter a plea of guilty, not guilty, no contest. And that if you plead guilty, then you basically waive your rights to a jury trial, and then you would go on to sentencing. Most people initially at arraignment plead not guilty so that you can engage in some, either prepare for trial or engage in some sort of meaningful bargain with the prosecutor. You could enter a plea of no contest. That's basically saying that that you are saying that you're guilty, but you're not admitting responsibility for committing the crime. And then an individual would plead not guilty because an individual could plead no contest because they are trying to avoid a civil penalty, right? So if you plead guilty, you're basically saying that you're responsible. If you plead no contest, that no contest plea is going to be treated by the courts as a guilty plea. But then if you get sued in a civil court, then the guilty plea can't be used against you because you didn't plead guilty, you pled no contest. And then that if you enter a guilty plea, then counsel will be assigned. And then also at that point, the judge will determine whether a bail will be set. So if you plead not guilty, then that a bail determination will be made. If this person is seen as a flight risk or really dangerous to society, they could say that that no bail will be set, that you'll just be held in a confined space until the trial takes place. However, most of the time bail is set, but it's usually so expensive that people can't afford it. Even if it's not expensive, people can't afford it on a moderate means. And so that the bail is set, and at that point, if you can't make it, you will remain in a secure confined environment in preparation for your trial. Okay, so the criminally accused is arraigned. They are told of the charges, that they plead not guilty to those charges. However, as we know, that 90% of cases don't go to trial. So even if you plead not guilty, that doesn't mean that you're actually going to go to trial. It's usually just the smart thing to do to plead not guilty. Not always, but in more major cases, it's smart to sort of plead not guilty, because then it allows you to engage in a plea bargaining arrangement. So 90% of cases do not go to trial. Most cases are resolved as a result of a plea agreement. And the agreement is what the prosecuting attorney and the defense attorney representing their client agree to. And that agreement is a process of bargaining, okay? So that the plea bargaining is an ongoing negotiation between the prosecutor and the defense attorney, that the prosecutor will charge an individual with the crime. The defense attorney will come back and say, we are not going to plead. We are not, as it stands, you charge my client with first-degree intentional homicide, that they are going to go to trial because they don't think that you can find my client guilty of that. And so that then there'll be a negotiation. Well, maybe reduce the charges, so that, and if you do, then my client will avoid trial and reduce and plead guilty to a lesser offense. And that's a part of the courtroom work group. Remember that the courtroom work group, the defense attorney, the prosecutor, if they're working together, they have a shared goal of trying to get through the court system as efficiently as possible and to avoid trial. So plea bargaining and plea agreements are a big part of that. Now, the judge isn't supposed to participate in the plea deal itself, in the plea bargaining, okay? That because the judge is supposed to be impartial, they're not supposed to be advising defense attorney or advising the prosecutor about whether they should lower the charges and what they should lower those charges to and what kind of recommended sentence they should make, right? They're supposed to be on the outside of that. So as it says there, the judge is not supposed to participate in the bargaining for a plea agreement. The only thing that the judge does is that they accept the deal, okay, or not. Judges are not bound to accept the deal, but courtroom work group, usually when a plea's been worked out, the judge will accept it. So, sir, some of the bargaining aspects of the plea agreement between the prosecutor and the defense revolves around, some of these sort of activities. And so the defense attorney can encourage or ask for charges to be reduced to a lesser offense, right? And so if you drop the charges, or not drop the charges, but if you reduce the charges, the defense attorney will say, my client will be more likely to plead guilty and we can avoid trial. That also the defense attorney may ask the prosecutor to reduce the number of charges. Okay. So, like, sometimes people are charged of multiple offenses. That is potentially going to increase the sentence that you would receive. And so the defense attorney can work with the prosecutor to say, hey, drop some of the charges, keep the more serious ones. And then that can be, sort of a, something that my client can agree to, or drop the most serious offense and keep the other ones. And that's something that my client can agree to. That the defense attorney could ask the prosecutor to, hey, can you recommend a more lenient sentence? So if they do plead guilty to a lesser offense, can you recommend sort of a sentence that's on the lower end of the sentencing recommendations? Also, they might say, hey, my client will plead guilty, but only if you can recommend probation to the judge rather than an actual sentence. A final sort of bargaining tool that the prosecutor also wants to avoid trial too, so they might be open to some of these things. And so they might say, hey, we'll change a charge from a charge that has a negative label like sex offender to something like aggravated battery or aggravated assault, and that way that the defense attorney's client could avoid sort of a negative label, but then also a negative label that comes with some consequences like having to sign up for a sex registry, etc. So those are some of the things that the prosecutor and the defense attorney will keep in mind as they are working towards a plea agreement. That there are lots of pros and cons of plea bargaining and the plea agreement. You've read about them and Locked In. One of the, on the plus side, that it reduces the overall cost of the system. So avoid a trial. Trial is really costly. It increases efficiency, that because less people are going to be involved if the trial is avoided. And also, if you avoid trial, then the prosecutor can spend more time on more serious crimes, and also defense attorneys can spend more time on preparing their clients to defend against more serious crimes. Obviously, it raises the danger that an innocent person will plead guilty because they're poor or a minority. And so they might feel like as a minority, they might not get a fair shake if they go to trial because of jury bias, racial bias. And so they might just say, hey, I will plead guilty even though I'm not guilty because I do not trust the jury system. Also, you might plead guilty because you might not be guilty, but you can't make bail and you are losing your life, right? Your livelihood, you might lose your job, your kids might go into custody. So you might say, let's get this over with. I'm going to plead guilty. That it basically you are encouraging a defendant to waive his constitutional rights to a trial, right? And so we all have these rights, and that if, you get this sort of push from your defense attorney to plead guilty, then you're basically being sort of encouraged to waive your rights. So some pros and cons associated with plea bargaining. There are legal issues with plea bargains that need to be abided by, so it's not a free-for-all. For a plea agreement to be constitutional, the criminally accused must have not just counsel, but effective counsel. And so the defense attorney has to be working to the best of their ability to vigorously defend their client, even in the process of the bargaining. An individual cannot be pressured to or coerced into agreeing to a plea agreement. The agreement must be made voluntarily. If the prosecutor promises things such as a reduced sentence or to a reduce of charges or a recommendation to the judge to reduce and be more lenient on the sentence, They must hold up their end of the promise. So if you get somebody to plead guilty, that has to be predicated on the promise that you made that you're going to reduce the severity of the charges. And that the judge should not be involved in the process beyond approval, denial of bargain. So if there is evidence that the judge is working with the prosecutor, they're like kind of in cahoots about, yeah, if you go for this sentence, I'll agree to it. Well, then that would make it an illegal plea bargaining procedure. Okay, that's it for pretrial procedures. Next lecture, we're going to look at trial procedures. Thanks a lot for listening, and I'll talk to you again soon.